being mentioned.
Please, Your Lordship. Lordship, I'm seeking the indulgence of this Honourable Court, my Lord, for an unlisted motion, my Lord.
Today?
Lordship.
What's the matter about?
This is for appointment of Nukmaship, my Lord. They're going to be appointed today itself.
So, if they're going to be appointed today itself,
Lordship.
By the time the order gets there, he'll already be sitting in the office.
Well, we have already submitted an application also, my Lord, to...
So why did you push it before the CM? Why are you coming here for unlisted motion? Order has been passed finally for appointment.
No, not yet, my Lord.
Then?
No,
are you anticipating appointment or appointment order has been issued?
No, they are going for registration, my Lord. For registration of Nukmaship. That is why I'm coming before this Honourable Court, my Lord.
I don't know how urgent is that. If they're going for registration,
no, because
doesn't mean they're going to get appointment today.
No, once it is registered, my Lord, then the matter will become redundant, my Lord. That is the reason why I'm coming for this Honourable Court.
How will it come? How many matters you moved yourself where you've been registered and it's a matters pending here?
Lordship, if they are appointed, then it will be a problem, no, my Lord. That is, so I'm just seeking, my Lord.
How? Has it already been filed?
It has all been filed, my Lord. It has been registered as well, my Lord.
We'll see. If it's not urgent, you're going to pay cost.
Lordship.
Yes.
Your Lordship. I'd like to make a mention, Your Lordship. There's an urgency in the case in relation to the auction of...
Auction of who?
That will be conducted on the 26th, Your Lordship, on Monday.
Auction of what?
Of movable, Your Lordship. This is a matter where the petitioner's
pursuant to a decree.
Yes, Your Lordship. The matter is related to auction of classification of a unit which was legal. It was declared as an illegal unit. So without proper authority.
A sawmill?
Not sawmill, Your Lordship.
So what unit is that?
A crusher unit. A crusher unit.
Auction by whom? By the Pollution Control Board?
By the Deputy Commissioner, Lordship, Ribhai, along with the State Pollution Board and the Forest Department.
Okay, let's see. It's connected with environmental violation?
Partly, Lordship.
You're in the same matter? Yes. Since I've opened the door for Mr. Moomin, I can't close it for you, yes.
May I please?
You also understand the motion?
No, my lord. I'm mentioning item number 33 here in English.
33?
Yes. I have already taken consent from the petitioner.
Pakistan Sangma?
Yes.
Why? Personal difficulty?
Because I didn't get instruction from the director whether pension is processed or not.
Mr. Isareka, please that the matter be adjourned for 2 weeks to enable him to obtain instructions as to whether pension has been released to the petitioner. You're for the petitioner, correct?
Yes, petitioner.
33?
That is for health department, my lord, because already forwarded everything here.
Item 33, you're sure? Because your
yes,
name's not here?
Bagishan Changma.
No, your name's not here. I see K.C. Gautam and...
No, from state respondent, my lord.
Or state respondents?
Yes. Mas.
Yes, clip 101. Yes, Mr.
Mention item 24.
One second, we're just mentioning 24 right now. 1 second. Next, you'll come.
24 decision. Let's come for 3 weeks.
3 weeks. Yes, 25. What do you want? No, we don't give dates. You take, that's not at your convenience. 6th of July will be around after 3 weeks. Okay. Okay, yes, after 3 weeks. Yes, thank you.
May I please, Your Lordship? I beg to mention number 34. The latest matter after 2 weeks. And for the respondent number 1 and 2.
Number?
1 and 2.
Number?
34. Item number 34.
Respondent number 1 and 2. Where's the petitioner? 1 and 2. Have you informed the petitioner here for the respondent? You have objection?
No.
3 weeks?
2 weeks.
2 weeks, okay.
Much obliged.
Item number, I beg to mention item number 29, Lordship. I'm for the petitioner, Lordship. I need some time, Lordship.
How much?
3 weeks, Lordship.
Take 6 weeks also to fully prepare. 3 weeks, okay. On the personal difficulty, Mr. Sheikh.
Apply, Your Lordship.
Lordship, I beg to mention item number 35, Your Lordship.
35.
2 weeks time, please.
You're for the petitioner?
Yes, Your Lordship.
You have objection?
No, Your Lordship.
No. 2 weeks, yes. What's your name?
SS Norum, Your Lordship.
SS Navrum. Yes.
Lordship, I beg to mention item number 30, Your Lordship. I'm for the respondent number 2, Your Lordship. Counsel Mr. P. Ubin is out of station, Your Lordship.
Mr. Yubin is practicing in Delhi now, or he comes to Shillong sometimes?
No, Your Lordship, now he's in the Arunachal Pradesh.
Okay. 2 weeks. Yes.
Deeply obliged, Your Lordship.
Due to as the High Council's out of station. Yes.
May it please, Lordship. Lordship, I beg to mention item number 31, Lordship. It's a teacher matter, Lordship, and it appears that similar matter has been decided by this court, and we want to look into that order, Lordship.
What are similar matters decided, Mr. Prasaji?
Which matter is that?
Some other matter, one.
Some matter. No.
Yes.
What's the issue here?
It's a where that this the petitioner is removed from service.
No, it's
From-
another
as a
judgment has a
assistant
bearing
teacher.
on this one.
Yes.
What bearing does it have? Yes, Mr. Karma.
And this
What's the matter
Meghalaya
about?
teachers eligibility test, Lordship. Blooming Star, Lordship.
Okay. 2 weeks, yes.
And Lordship, I also beg to mention item number 32, Lordship.
32. What's it doing 32?
Lordship, this matter, I pray for 2 weeks' time, Lordship.
All the matters have got 2 weeks.
But here the appointment is
MPS
withheld, my lord, because of the pendency of the matter.
What appointment to which
I'm the
post?
duly selected candidate, my lord.
To which post?
This social officer, Lordship. Social officer.
Why are you joining it?
It's almost 2 years.
Lordship, some difficulties, Lordship.
Where's Mr. Changrai? So,
Lordship,
if
this
it's
is
holding
on
up
next
someone
before
else's
division bench,
appointment,
Lordship.
then that is not really fair. Do they have a case?
Though there is no stay out also, my lord, but the government is
1 week. Okay. After 1 week. Huh?
Highly obliged.
That's it.
Supplementary list, item number 1.
Yes, what's the matter about? Yes, Mr. Sai.
Lordship, before counsel starts, in this case, the petitioner, the respondent number 2 is represented by PNP in the low court.
Pinambri as in Philamonambri or Philamon?
Represented the respondent number 2 before the
Number 2, he's here. He's arrest party here. This is matter before a bench brought me.
Item number 2.
Sorry, Mr. Khera. Some matters I can't take up because he's my cousin.
Lordship, I have one small request here. If this matter could be, because I'll be out of station for 1 week.
I can't pass any orders. If you see, if I recuse myself, you can mention it before the other court today itself.
Obliged, Lordship.
Because it's not sitting now, I think the single bench.
Obliged, Lordship.
Sorry. Like these things happen.
Lordship, here this is the second round of litigation, Lordship. Here the petitioner was earlier appointed the assistant teacher of LP school, Lordship. That the appointment order is at page 11, Lordship. We have taken 2011.
Page?
11. Then his contractual.
One second. Page 11.
Annexure 1, Lordship. Then his contractual appointment was extended till 2019, Lordship. That is page 14, Lordship.
Okay.
Then after 29/6/2019, Lordship, then my renewal was not extended, Lordship. That my appointment was not extended. Then I have
After 8 May 2019. After
29/6/2019, Lordship.
29/6, okay, then?
Then I approached to this honorable court. Then court has directed to dispose of my representation, Lordship. Then that is at page 17, my Lordship, that my representation was disposed of. Page 17, Lordship.
Yes.
That may I read, Lordship?
Yes.
In pursuance of Honorable High Court order dated so and so, the representation dated so and so filed by Sri Raskishar Pandey has been perused and examined. On examination of his representation and the records of the office, it is found that the petitioner was appointed on contractual basis by so and so. However, his extension was not issued with effect from so and so. On further perusal of order, it is noted that the similarly placed other persons, namely Shahul Islam and Ainul Haq, were allowed to continue on 59 days basis so and so. In view of the above observation of the facts, it is found that Sri Raskishar Pandey should also be similarly placed with the other mentioned above. I therefore hereby direct the sub-divisional education officer Dadangiri shall issue extension order to Raskishar Pandey with effect from so till the appointment of a regular candidate under Dadangiri subdivision, my lord. Thereafter, my lord, my service was continued, Lordship. Then again, my lord, that is at page 18, Lordship. Then after that, the last extension order was given 29 June 2022, Lordship. After that, my extension was not given, Lordship. However, the similarly situated person, Lordship, that director has mentioned in his orders, in the meantime, their service has already been regularized, but my contractual appointment was also not extended, Lordship.
No. The other people regularized were similarly situated like you?
Yes, Lordship.
Where is that order?
Page 20, Lordship.
No, where this is page 20?
Page 20, Lordship.
No, this is regarding pension. What is this?
No, my lord. This is for that is why that since his post was regularized, that is why the department has.
No, on what basis were they regularized? Have you made any statements in the writ petition?
Yes, Lordship.
Where do you see it? How do you know they regularized and allotment of permanent pension account number? It's
Yes,
the same person as Shahanur Islam
Yes,
and Inal Haq.
Yes, Lordship. Which were referred in the director's order, Lordship.
No, under what terms were they appointed? Maybe it's different.
No, we are same with the same 2011 and 2000. My lord, kindly see, my lord, page 14, Lordship. Their name also reflected.
Page
14, Lordship. The serial number 4 and Lordship
number 2.
And it has been reflected in the director order that I am also similarly situated. That is why director had given order for extension, Lordship. Here I am not praying for regularization. At least my contractual.
You have received instructions?
No, just now I received the file, so your lordship, I may be allowed 2 weeks time to get the instruction and maybe allowed to.
Issue notice. MS Haji is present, accepts GM doesn't accept notice on behalf of all the respondents. Stop. Next paragraph. The case of the petitioner is that similarly situated candidates, similar to appointees such as him, similar situated candidates who have been regularized against the post they are serving against. Stop. However, at this stage, Mr. S.E. Sheikh, counsel petitioner, has only prayed for extension of his services, which were not extended after.
Not extended till, Lordship.
After
24/6/2022.
24/6/2022. Stop. Next paragraph, MS as per to obtain instructions by the next date, just after 2 weeks, for instructions or affidavit.
Because this is in Dadangiri. So
How far Dadangiri?
Dadangiri, because I'll just send WT message, your lordship, so they will come and collect the copy.
3 weeks, okay.
Much ado.
Item number 2, 3.
Yes, Mr. Anna.
May I please, Your Lordship. So this is regarding disbursement of pension, my lord, and other service benefits. I have been retired on 30th 11/22.
30th 11.
22. Till
So you were
date,
serving as?
as work charge roller driver.
Were you put in the RCW scheme?
Yes.
Work charge only?
Work charge only. Work charge roller driver.
Are you permanent benefits or pension? Are you entitled to pension?
Yes, my lord.
Where is that order? Yes, yes, I would only request that he stop.
Page 28, my lord. 18, my lord. That my pension has, and other benefits have been stopped due to some.
You are Sapan Burman?
Yes, I am Sapan.
Okay, you regularize. Huh? Okay. 6. This is petition by your wife or by you?
No, what, my lord, what happened?
Why she made a complaint against you?
We are living separately, my lord. For instance.
Oh, that is the reason.
She has filed the maintenance case that is pending, and I have been paying dues time to time. Now,
it's not a question of straight non-payment of pension. See, this one is not shown to 18 says that letter of intimate received from wife Srimati Sangari Barman. She has made request not process settlement of your outstanding dues, special benefits as a case is pending in court.
That cannot be, my lord. On that application, my personal pensionary benefit cannot be stopped.
I'll take instruction.
Heard Mr. Vicharnath, the council petitioner issue notice. Mr. S.E. Sheikh accepts notice. You not made your wife party on behalf of all respondents?
Here, my lord, that was my thinking, because that wife should have been, because
yes. What is the reason why? The reason why she is asked to stop?
Yes.
Why you not made her party?
This is a question between the department and my pension, my lord.
Okay, be that as it may, it's your case. How you make your bed, you have to sleep on it. Yes, heard Mr. Echana issue notice. Mr. S.E. Sheikh, then GS present acceptance on behalf of all the respondents. List about 2 weeks for instructions. Affidavit.
Item number 4.
Fully having a point. Some previous.
Please, Lordship.
Yes, Mr. Dev.
This is a review petition, my lord. There's a delay of 48 days.
What review of what order?
Review of the order, my lord, passed on 3rd of April by this honorable court, my lord.
On what ground review?
The case was, my lord, that the petitioner, after being selected for appointment in the SF10, before he could join the service, my lord, he was implicated in a case in Tura. Right after the bail, my lord, we had submitted a representation to the authorities to allow him to join the service, my lord. That was eventually rejected on the ground that there is a pending criminal case against him of serious nature, my lord. The matter was heard, my lord, on 3rd of April 2023, and the matter was dismissed, my lord, on the ground that the case is still pending. And since the case is still pending, I have no right to claim for the joining, my lord. But the fact was, my lord, that since January 2022, he had already been discharged from that said case, my lord, and that case has already proceeded in its own course, and the petitioner has no role in that case, my lord. But that crucial fact, what happened was, at the time of the dismissal of the case on the ground that, my lord, that case is still pending, Lordship may kindly have the order at page 30 of the review petition, my lord. If I may read page 31, my lord, paragraph 4.
Yes.
Mr. S. Deb, learned counsel for the petitioner, submits that rejection is unreasonable, arbitrary, inasmuch as petitioner has never concealed the fact that there was a case pending against him before the respondents, and that he was on bail. He further submits that the requisites that are applicable to regular employees will not apply to him, as he is yet to be confirmed into service. At this stage, he solely submits that his prayer is that the respondents be directed to allow the petitioner to join the post to which he has been validly selected. Mr. B. Bhattacharjee, learned AAG, assisted by I. Lingwas, learned GA, for the respondent, submits that firstly it is to be noted that representation was filed by the petitioner dated so and so after bail had been obtained on so and so. It is further submitted that the fact is that a criminal case which is serious in nature is pending adjudication, and it's not the case where the petitioner has been acquitted and is seeking appointment. Thereafter, my lord, certain judgments were also relied, and essentially it was dismissed on this ground, my lord, that the serious criminal case is pending against of me, which is why I could not be appointed. But lordship may kindly see, my lord,
Where's the finding?
Lordship, the finding is at page 34, my lord, page 9, paragraph 9.
Yes.
The entire issue was, my lord, that the criminal case was pending against of me. That's why I could not seek, my lord, the appointment. But the fact was, long before that, lordship will find at page 35, annexure 2, charge sheet of 2022 January, my lord, I was already discharged. In fact, I was not charge sheeted. And
This is the fact that was prior to the disposal of the case.
Yes, my
which
lord.
had been to your knowledge.
No, we
It's
had
not a new fact.
We had said, my lord, that we are not aware of the pendency.
How will you not be aware if he was your client?
We even taken that ground, my lord, that we were not aware, and even the state respondents could have, my lord, brought to the notice. But the ground on which the case has been dismissed.
Where the discharge?
Lordship may kindly have the order at page 45. Page 45, my lord, annexure 3.
Yes.
Lordship may kindly see the second paragraph, my lord. Seen from the records that wide order dated 21/2/2022 passed by the learned CJM Tura, accused so and so Shri Chalang Marak, my lord, is the petitioner here, and some other persons have been discharged from the liabilities of this case, and this instant case proceeded against lone accused Shri so and is at the stage of copies. Thereafter, my lord, the case has been committed to the learned sessions court, and it has been proceeding against that Mr. Ahmed Hussain, and we are nowhere involved, my lord, the petitioner. And they had also filed their affidavit much after this order, my lord. It was not brought to the state respondents, lordship.
Is your job or their job to?
No, I understand, but we had, my lord, said that we are not aware, even that ground
Yes,
is
Mr.
taken.
Bhattacharjee. We'll continue to delay. We'll
I'll
dispose
have
of
to
review.
start with some technical objections. Kindly see, my lord, the application for condonation of delay under section 5. Can section 5 be invoked in a writ petition, my lord? Can limitation act apply, my lord, in a writ petition? Now, my lord, he has followed the CPC here, my lord. That is cannot be, my lord. The section 5 would not come, my lord, in a writ petition. So, lordship, my lord, the question of condonation will not come. If it is a writ petition, my lord, the principle of delay and lecture should come. Limitation doesn't come, my lord. So, this petition basically is not required to be entered.
No, on the main ground, set out.
Now, my lord, so far as the review is concerned, my lord. Now, as my lordship has already noticed that his discharge was prior to the disposal of this case. Now, my lord, what happened? Issue was confined to rejection of his representation. Now, this representation was rejected prior to his discharge. In the writ petition, we are concerned with the thing, my lord. So that way, my lord, so far as the order passed by this honorable court doesn't suffer from any infirmity. It was not his case that he stood discharged at the time when department considered his representation. Now, my lord, he says that he has been discharged. Now, if he feels that discharge will basically make him entitled, my lord, he has other remedy.
Exactly.
He cannot come by you. There is no ground for review, my lord.
No, my lord, because the entire
This court kindly, my lord. Now, my lord, kindly see the order passed this honorable court. This honorable court, my lord, it says is paragraph 9, my lord.
Yes.
It says, my lord, in the instant case, it is no doubt that the writ petitioner who is yet to, my lord, I am reading page 34,
Yes.
who is yet to enter service and whose appointment is yet to be confirmed, Now, my lord, the appointment is yet to be confirmed, my lord. Was arrested in connection with so and so, so and so. The judgment passed by the in the same times will not allow consideration of petitioner's prayer as made in is made out in the writ petition. It is also not a case that the petitioner has not given a fair opportunity to represent before the impugned order was passed. Accordingly, the facts and circumstances of the case, as discussed above, there being no merit in the instant writ petition, the same is dismissed. Now, this honorable court has never said that he is not, my lord, qualified to be appointed or disqualified to be appointed. Now, if he feels that he is qualified, my lord, he should seek other recourse, my lord. This review will be no answer to you.
Yes. Anything else to say?
My lord, my humble submission is that, my lord, as regards the limitation, this court has the power.
Limitation, will condone whatever.
On the main aspect, my lord, the categorical submission was that there was a criminal case pending, hence I could not be.
Take down Miss Case Review Petition number 4, 2023.
My technical objection, my lord,
Yes,
remains
no
with
technical objections have been raised.
and with review application also. my lord.
Yes.
Because it has been, order 47 has been invoked here.
Yeah, it's been overlooked.
My lord, these are settled law, my lord.
Yes, of course. The review petition, Miss Case Review Petition number 4, 2023, and review petition number dash of 2023. Stop. Though the instant application of conditionality is not though the application for condition of delay in filing the review application is condoned or the delay condoned, though technical objections have been raised by learned AAG that the style and format is not in that the set applications are in proper form. Stop. Register the review application.
My lord, I do not say in proper form. I say limitation act will not be applicable.
Oh yes.
So, lordship,
form
my,
as
lord,
limitation act.
my objection goes to the extent of saying that my lord will not have any power under section 5 to condone that.
Yes.
The question of condoning delay doesn't come in the petition. So this is not required, my lord.
Okay,
Even
then,
if lordship
okay, we'll style it differently.
Well,
So this Miss Case number so and so. This is an application under this application has been made under section 5 Limitation Act for condonation of how many days delay?
48.
48 delays preferring the collected review application. Stop. Mr. SDEP submits that the delay was occasioned due to. Where have you made out the grounds?
Lordship, at page 4, my lord, paragraph 4.
At paragraph 4 of the said application, stating financial constraints and other
In the copy.
constraints and the delay in obtaining the copy, which has occasioned the delay. Stop. Mr. Bieber AAG has submitted that the instant application in itself is not maintainable and does not deserve any consideration, as firstly the Limitation Act is not applicable in matters under Article 226. Stop. Heard the counsel for the parties. Stop. The fact, the technical objections of the General AG are noted. However, in interest of justice, the delay is overlooked as it is amounts only to latches on the part of the writ petitioner. Register the review petition. Stop. To register the review petition. Stop. The main review petition. So Mr. S. Deb submits that the reason for preferring the instant application is that the fact that the writ petition has been discharged from the criminal case on
21st of February, my lord.
21st of February 2023.
2022, my lord.
2022. 2022
Lordship, yes, my lord.
was not to the knowledge when the matter was disposed of on 3/4/2023. He submits that this fact being crucial to the petitioner's joining in service could not be brought to notice of the court, and as such, the judgment was passed dismissing the writ petition. Stop. Next by Mr. B. Bharat Sajilas, counsel petitioner for AAG. AAG for the respondent submits that the discharge of the writ petitioner has no connection with the disposal of the writ petition, which was on a totally different ground, inasmuch as the representation of the petitioner was already considered by the respondent on its own merit. Stop. In view of the submission, in view of the submissions and looking at materials record, no grounds submitted for review, and the same dismissed. Yes.
Item number 5.
Obliged, Your Lordship.
Yes, Mr. Jindal.
Your Lordship, in this,
What do you want the court to do now?
parties have come to a settlement which has been annexed with the petition as Exhibit X, and everything is settled. It's a matter between two brothers. And our submission is this, that Your Lordship will record this settlement by making it a part of the order and dispose.
Then we are direct for drawing up decree also then.
Yes,
We
Lord.
have the decree to be drawn up in terms of the
Yes, it's compromise agreement.
Then we'll pass orders.
Yes. This is registered a miss case, and in view of the order passed in the miss case, the first appeal and the miss case of the first appeal will also stand disposed.
What about the suit pending before the trial court?
That also we have withdrawn. Yeah, it is already stated in the
Stated here.
compromise. I'll leave that.
Item number 6.
What is this, Mr. Thaba?
Lordship, I've filed an application with a prayer for status quo order. Your
Status quo with regard to?
Lordship, the mining lease of the petitioner company expires on 24/6/2023, that is tomorrow, Your Lordship. So, and in between, Your Lordship, we've received several communication from the opposite parties, especially opposite parties number 4, 5, and 6. That
Offence 6 Chief Secretary, Divisional Force Officer.
I'm
Director,
sorry, Your Lordship. Number 2, 3, Your Lordship. Opposite
Senior-
parties number 2 and 3.
2 and 3. Regional Controller of Mines. Who's representing them?
I'm ready.
Okay, yes. And Senior Mining Geologist.
Yes, Your
What are they objecting to?
Your Lordship, they have sent several letters. For example, letters dated 24/11/22, letters dated 13/12/22, letters dated.
So what do the letters say?
Lordship, they have alleged that
Let's
we
see
have.
what are those letters? Let's see them.
Yes, Lordship. Your Lordship, Annexure 1, page 14.
Yes.
They have alleged that we have not submitted the monthly return for the month of October 2022 to the opposite party.
What returns are these?
And these are monthly returns, Your Lordship.
What monthly returns what for?
Your Lordship, they have to file monthly returns to the opposite party number 2 and even annual return. Even though, Your Lordship, the company has been suspended since.
No, but what prevents you, if it's suspended, what prevents you from filing returns then? Is as per the mineral concession rules?
Yes, Your Lordship.
Okay.
Your Lordship, the company has been suspended since 23/3/2020, Your Lordship. So, Your Lordship,
Company's been suspended. How can a company be suspended?
the suspension order was given.
No, how can a company be suspended?
The operations of the company. Your
For the
Lordship.
operations of the company?
Yes, Your Lordship. So,
Then?
the operations of the company were suspended since 23/3/2020.
Okay.
Lordship. Thereafter, we have approached this honorable court by the writ petition number 90 of 2020, Your Lordship, challenging the suspension order. passed by the opposite party number 2, respondent number 2, Your Lordship. Thereafter, Your Lordship, on 16/3/2021, Your Lordship, an order was passed whereby the representation dated 12/2/21, which is Annexure 16 of the writ petition, was to be considered, and it has been stated that needless to mention.
Mr. Thaba, just make, I mean, like this court, just make this court understand. By this mis case, status quo, you want on what actually? Yeah, this annexure 1 is like non-filing of returns, okay? Then annexure violation of okay, of the provisions of mineral conservation development rules.
Then
no, why can't you submit the returns? What is preventing you?
Lordship,
if you're not operating, your company
we
is functioning. Your company is functioning. Then it's mandatory that you file. If zero returns, also you file 0 returns.
Yes, Your Lordship. We have been filing. It is only for the month of October that we could not file because the person who was supposed to file was not well. He was very sick. So only for that period, only for that month we couldn't file. And then, Your Lordship, Annexure 4, Your Lordship, page 17, whereby we have not, they have stated that we have not submitted the annual return for the financial year 2020-21 to the opposite party number 2. Now, Your Lordship, when the petitioner tried, number 2, tried to fulfill the, to file the returns, the annual return, when he reached a page.
Is there a provision for?
My Lord, may I
yes.
Submit, my Lord. My Lord, the petitioner company was granted mining lease for limestone, my Lord, over an area of 240 hectares, my Lord, in Komura. Now they're carrying out mines. What transpired, my Lord? The state government has leased out out of the same 240 hectares of land
That is, yes,
to some other people also, my Lord.
Yes.
When this came to our notice, we wrote to them that how can from the same mining area you are also a lessee and some other people also lessee. And those leases were given as minor minimal for extraction of limestone for domestic use, my Lord. And their license is for as major mineral, my Lord. Now the lease expires in 2023, my Lord. Now as per the rules, they have to keep some money with us as in the form of bank guarantee, because after the mining lease expires, my Lord, there are certain formalities for closure of mine, my Lord. So for that, a bank guarantee is kept that the closure of mine is done as per the rules, whatever covering and all those things, my Lord. Now their bank guarantee is expiring, so we've written to them that please renew the bank guarantee. Otherwise, the department will be without anything, my Lord. So that is the immediate cause of action for which they have come, my Lord.
No, but why? But no, he's come against the status quo and submissions of
returns,
asking for returns.
Returns of 2022, my Lord. Lordship kindly sees those letters, my Lord. Those are the letters of last year, my Lord. Some of the letters.
But Your Lord,
yes, 22.
Yes, Your Lordship, they have even gone to the extent of writing to the branch manager, State Bank of India.
No, see, Mr. Thaba, you have to understand, you're functioning in statutory, it's under statutory regime, correct?
Yes.
And so, if you're a company under statutory regime, you have statutory obligations.
I understand.
Correct. And so, statutory obligations demand that the company, fulfill those obligations. They have to fulfill them in accordance with law.
I understand.
Now, if you're not managed, so might be your operational company has been closed, but you have to fulfill those obligations, notwithstanding anything else.
Yes, Your Lordship.
And so, unless suppose the company is wound up, is a different thing. But the company still exists. The operations only have been stopped for some reasons we don't know. But then it is incumbent upon you to file the returns. And then you cannot say you won't file the returns because you're not operating, and then mining is expiring, and now you come for an order for status quo. Status quo, what to stop them from acting as per law?
No, Your Lordship, I'm not saying that. Your Lordship, that is not the only issue, Lordship. There have been several other letters. Your Lordship, those 2 letters were only for the returns, and they have also written regarding the
page 34. Page 34 is against which they have come now.
34.
Your Lordship, not only regarding this is regarding bank guarantee, for which they have given us letter that we should pay the difference. Now, Your Lordship, my main contention is that, Your Lordship, Annexure 16.
16 of this application.
Page 38, Your Lordship.
What does it say?
Your Lordship, the petitioner number 2 had gone to the extent to write to the OP number 5.
You have written this letter?
Yes, Your Lordship. To exclude the land given to the private individuals from the lease land of the petitioner company. Because
so now your stand that you're going to close the mining totally. You'll wind up the company also.
Your Lordship, for that we had even filed a final mining closure plan, which was not approved by the opposite party number 2. Now, Your Lordship,
let them take instructions on it.
Your Lordship, because the mining lease is getting expired. So if the mining lease gets expired, the entire writ becomes infructuous, Your Lordship. So to enable us
to one thing, Mr. Thaba,
rectify.
These letters were issued in February, March. You've come here on today is the 23rd, correct? Or today is the
23rd.
Yes.
Your Lordship.
What do you expect the court to do?
Lordship, since if a status quo order is not passed, Your Lordship,
status quo order for then all the proceedings which they have to, they have to,
no, Your Lordship,
exercise against the company will have to be stopped.
No, Your Lordship, it is because the mining lease will expire tomorrow, so the entire writ will become infructuous.
Doesn't matter. Why will be infructuous? Then why do you file? Wait until tomorrow, then the whole matter infructuous. You don't have to even go for it. You don't have to file the miscase case also.
Lordship, we've come before this on court, Your Lordship.
See, once a writ petitioner comes to the court, Mr. Thaba, the court tries to help them. If you come to court, you have a serious grievance. But then you have to make out a case in which way that the court can help you. Coming to court doesn't mean you just come to court for a lark.
No,
right?
Your Lordship.
The deal of the court is take the person in hand. Okay, what is your problem?
Yes, sir.
But if it's such a manner that the letters have been issued since 22, you never came to court against 22 letters, non-filing returns.
These letters were received by us in the year 23, Your Lordship. Just recently.
22 letters.
Yes,
letters did 22.
Yes, Your Lordship. Because, Your Lordship, if I may just take Your Lordship to.
It becomes
Annexure
9th of March 22.
Annexure 9, Your Lordship.
Okay, let's look at Annexure 1. Okay, he said this is the first letter. This is 24/11/22. Next letter is 7/12/22, or is your reply. Then you say you got it in 23, then you replied. You got 24/11, you replied on 7/12.
Your Lordship, if your Lordship may come to Annexure 9, Your Lordship, page 25.
No, sorry, Mr. Thaba, we can't stop, the respondents from exercising the statutory duty.
Yes, Your Lordship.
Then?
Your Lordship, Annexure 9 is a letter written by the opposite party number 2 to the opposite party number 6. Request to hand over 2 numbers of violation letters to MD KLMC. If I may be allowed to read, Your Lordship.
See, this violation regarding the lease is not to do with the non-submission of returns.
Your Lordship, because all these are integrated, Your Lordship. And Your Lordship, if Your Lordship allows me to read this letter.
That your office is locked?
Yes, Your Lordship. Because
so how can I help it?
So these letters were received by us.
Heard Mr. D. Thaba, Miss case number 91/2023 in WPC number 90/2021. This application has been passed seeking status quo orders. The prayer, he said, please, for the end of justice, status quo orders on what? Seeking status quo orders without there being any specification of status quo as
Lordship, because once the lease period expires, then everything becomes.
Then you're free.
No, Your Lordship, because so as to allow us to rectify whatever mistakes we've made, Your Lordship. That is the only prayer, Lordship.
with a prayer for status quo without specifying the nature of status quo sought for. Stop. Letters have been annexed to the business application indicating the factum of violation of the petitioner company, applicant company of the, one second, that is the, what are those rules called? Of the Mineral Conservation and Development Rules 2017. Stop. Next paragraph, next by Dr. N. Bozika, appearing for the respondents 1, 2 and 3, and MS Kolni for 4 to 6 to seek instructions. This up to 2 weeks. See, Mr. Thaba, you should have come much earlier.
Annexure 16 itself says that we have written a letter to even.
Have you asked for status quo of any specific thing? Look at your prayer.
So that we can rectify whatever.
You can rectify it post facto.
The problem started with lots of kindly page 38, my lord. The lease from the same land, my lord, the lease has been given to philosopher Yafunya Kuntimai.
That is done by the state respondents.
That'll be submitted with petition. Don't worry. We'll rope in those people also if they've done something wrong.
Okay.
Item 7.
Yes, Mr. Paul.
My lords, this is that MPC matter. My lords, I was praying for a little accommodation. For some urgent matter, my lords, I had to travel. Your lordships kindly have it on Monday, my lords.
Monday, I request Mr. K. Paul, Senior Counsel.
Main list, item number 1.
Wait, please, your lordship.
Yes?
Your lordship, I pray for 2 weeks' time to file my rejoinder as we are here to.
How many times have you asked for the rejoinder?
3, your lordship.
3? You exceeded 3 times?
I'm not sure, your lordship.
You're not sure? No more time.
Last chance may be given, your lordship, 2 weeks' time as we are yet to receive complete instruction from our client.
Same excuse made last time also.
Your lordship.
Okay, a final opportunity of 2 weeks is granted to the petitioner to file the rejoinder affidavit.
Respondent number 12.
Yes, sir, note. The respondent is number 12, Mr. Paske. Yes.
Much obliged.
Item number 2.
Here actually nothing remains for the petitioner to execute.
In fact, my purpose of the petition was served, but because the appointment of the private respondent has been cancelled. But,
matter ends, my lord.
Mr. Hazarika wanted
Matter
to
ends.
No, I have done in the last order, my lord, Mr. Hazarika wanted to.
What did he say? It's not his brief. You're the master of your brief. You're the petitioner.
I had already submitted that. It's a.
Mr. KB Bhattacharya, GA, submits as the nothing suffices for consideration of the petition as a please keep it down. Yes, sir. Where's your prayer, Mr.? Nothing suffices for consideration. I will just write nothing suffices for consideration as the prayer of the petition has since been redressed.
Yes.
The calling matter stands closed. Yes, as being fructuous.
Obliged.
Item number 3.
I'm praying for some time to file my affidavit.
Why has the review been admitted?
Yes.
What's the matter about?
This is that matter, my lord, where some kind of an orders were passed in the petition, my lord,
for demarcation, my lord.
For demarcation, without hearing me, my lord, without even making me a party in the case.
Oh.
Later on, it transpired that there was a property dispute.
My lord, the review petitioner brought the entire matter. The land it's a separate land, my lord. The patta number, tag number is
Have you filed affidavit?
No, my lord.
Then?
My lord, I'm just informed.
Yes, Mr. S. Deb, 1, 2, 3, Mr. S. Hassan are allowed 2 weeks time to file affidavits. This thereafter. You file it, and then we'll dispute.
4.
In this case, we are yet to file an affidavit. We have received instruction. Only my lord, Basically, we require some other technical information with regard to PSPL and of LD and typist, my lord, so that we can, my lord, file the effective affidavit in the matter.
How much time?
2 weeks time.
2 weeks time as granted to learn AG for affidavit.
Item number 5.
Item 5 to 17,
Where's the
I'm constrained
affidavit?
to seek further. Lordship, I'm seeking 10 days more time for that.
This is purely in bad form. You have not filed affidavit. I mean, we've given you enough, what do you call a latitude.
Lordship, I quite see that. I usually do not make such a request, but Lordship will accommodate me this time for a period of 10 days. The affidavit will surely be on record. I'll personally ensure that it's done.
Or else it'd be subject to heavy costs. This is not done. We understand you're in deep financial trouble and you're also suffering load shedding, but anyway, as a final opportunity, 10 days time granted to the respondents to file the affidavit is.
But in item number 12,
It's different.
government is also a party. Whether they will file any affidavit?
Item number 12, state respondents also directed to file affidavits
Okay.
within 10 days.
This is for 5 to 21.
5 to 21. Item 12, the government specifically directed. Item 12 only. But do you require to file or no? Or it's only on PCRC? Not required.
Hearing. Supplementary list item number 8.
Don't ask for time.
I'm not asking.
Okay.
It's a negress matter, my lord.
What your concluding remarks or submissions? What do you have to say? You say he has some authority, correct?
Yes, my lord.
Yes. Okay. The only thing is kindly.
On the corrigendum, my lord, there's one from the Honorable Supreme Court, and from SCC I got it, my lord.
Just tell the court what the judgments are about.
My lord, this is relating to corrigendum, my lord. What corrigendum means. So, my lord, this has been explained in a very
Can you kindly give a citation to the court also,
Yes,
so we will be
it has been
privy to it.
explained.
Yes.
Two citations.
You give citation other side.
I'll give him a copy, my lord.
Oh, very good. Any-
So, my lord, first, if I may be allowed to refer to, my lord, 2014 SCC online, my lord. This is relating to the Allahabad High Court, my lord, judgment. So, this is very detailed, my lord. May I take, my lord, to para 5 onwards, my lord.
Yes.
In my view, the submission advanced on behalf of the petitioner has force and deserve to sustain. The notification dated so and so reads as under notification so and so. So this is the corrigendum method. In condition 5 of opening paragraph of the notification of the Government of India in the Ministry of Finance, Department of Revenue, number so and so, dated 10 September 2004, published in Gazette of India. So and so, the words and figures under Rule 18 shall be corrected to be read as under Rule 18. Rebate of duty paid on materials used in the manufacture of the resultant product. So it clearly says that it is a corrigendum to notification number so and so. It is not an amendment or modification or alteration in the earlier notification so as to make a change therein as such. But when the author of a document makes a correction, it relates back to the date of initial authoring
for the reason that correction means whatever written was not correct or there was some mistake which need to be corrected. A correction or corrigendum precedes an inherent admission on the part of the person making correction, public issuing corrigendum, that the initial document or initial authored material has some mistake, and admitting this mistake, the same is being rectified, corrected, and hence a correction corrigendum. Normally, the word corrigendum is used.
Now, just stop there. Now, in this case, this first advertisement was in 2007, something like that.
Yes,
correct?
ma'am.
Second advertisement 2017, from 6 posts reduced to 4 posts.
Yes,
correct. Then corrigendum issued after 17 to see that it reversed back to 6 posts.
Yes.
And after what happened?
Then thereafter, my lord, select list was prepared.
And then they reverted back to 4.
No, then thereafter what happened, my lord? Select list was prepared, merit list, everything is out, my lord. Now, my lord, subsequently the selection, the committee again revisited. They cancelled the corrigendum.
Okay, then, yeah, okay.
They cancelled the corrigendum.
No, I'm just trying to recall. Okay.
Yes, my lord. Then they came out with
Okay,
new
get back to
results.
the get back to the judgment.
My lord.
Yes.
Normally, the word corrigendum is used when correction is made in a printed matter which has already disclosed, which has already disclosed to public, and therefore mere handwritten correction or draft or finalized matter would not be sufficient, but correction as such has to be notified separately, and that is how it is termed corrigendum. The meaning of corrigendum is an error to be corrected, especially an error in print. The word corrigenda is used in a list of corrections of errors in a book or other publications. The origin of the word corrigendum is said to be from Latin form, from the phrase neuter of corrigendus, gurdive of corrigender, to correct. In various dictionaries also, the word corrigendum has been defined. So, my lord, we have the Oxford.
Okay, fine.
And the, so, my lord, even in the legal dictionary.
Next decision.
So, my lord, it also refers to Honorable Supreme Court judgment, my lord.
Para 21.
Yes, my lord. Para 21 is also there. Then, my lord, it starts from para 16 onwards, my lord. 16, 15 onwards also, my lord. If I'm not wrong.
Yes.
Should I read para 15, my lord?
Of this judgment?
Yes, my lord, the previous. This court has also considered the nature of corrigendum.
We get it, yes. Next decision.
So this, my lord, in this judgment, this Honorable Supreme Court's decision was cited, my lord. So I have taken a copy of this. My lord, here the relevant para will be, my lord, this is 2004 7 SCC.
Yes.
673, my lord.
Yes.
State of Rajasthan, and another versus JK Udaipur Udyog Limited, and another. My lord, the relevant para would be, my lord, para 28, my lord. That would be at, my lord, page 689.
28.
28, my lord. Apart from this, the exemption being a creature of the scheme is subject to the scheme. Clause 9 of the scheme makes it clear that the right under the scheme was temporary, in the sense that the scheme could be modified or reviewed. It is true that clause 9 also provides that such review or modification could take place only in the public interest, but nevertheless, the right conferred was a modifiable or revocable one. If any right under the scheme is held to be unmodifiable, it would be contrary to the scheme itself. Therefore, even if one were to assume that the respondent companies were entitled to the benefits of the scheme on a par with new units under serial number 1 with effect from the date of the certification of their application under clause 4H, the right would be modified with effect from the date on which the scheme was modified. Further argument.
Where is in my opinion? Where's the line?
My lord, it says, my lord, there is no ambiguity.
No. See, reading this in continuation of where the judgment referred in the other judgment.
My lord, the further, oh my lord, in the previous judgment, my lord, in the previous judgment it is referred.
Para 20.
State
No.
of Rajasthan is in, my lord, para 16. My lord. Para 16 of the previous judgment.
Okay, then that's it. That's the only point.
My lord.
It's only touching to correct this one.
Yes, my lord. So the very, my lord, why is corrigendum issued, my lord? The basic thing is that, my lord, corrigendum is issued only for correcting a certain error or mistake, my lord.
Okay.
Now that was done, my lord.
Yes.
So once the corrigendum was issued, and
We had no
thereafter
occasion to revisit it ever.
Exactly, my lord.
Yes.
And thereafter the select list was out.
Yes.
Now, my lord, that means the whole process is over, my lord.
Yes.
Advertisements were issued, candidates participated, selection process carried out, result is out. My lord, after the corrigendum, then thereafter result is out. My lord, that whole process is over, my lord. Now, once that is over, the selection committee has no right to revisit, my lord. They could not have issued a subsequent notification stating that the earlier corrigendum stands cancelled. That
Yes,
itself
Dr.
is
Mosga, anything else to say? No.
That is
I pass orders.
My lord, only
course
one
already,
factor,
huh?
my lord.
Yes.
Because rather than what I'll request your lordship, my lord, rather than going to 4 seats or 6 seats, because the changed circumstances, my lord, now, my lord, that if lordship kindly comes to.
See, there's no question of changed circumstances. If the changed circumstances were there, then you withdraw the early advertisement and issue a fresh
my
one.
lord, what I'm saying, my lord, that originally 6 posts, 4 posts, he falls within 4 posts also, my lord. So my prayer would be not to ask us to fill up all 6 posts, my lord, because now he is within the range of 4 posts also, my lord.
Okay.
My lord, only, my lord, my humble prayer, my lord, because in this case, my lord, this is a fit case, my lord, where this honorable court can direct the respondents to appoint.
My lord, few facts, my lord, may I just.
Okay, yes, please. I can't shut you down. Yes, submit.
Well, just to assist, my lord. My lord, I've given a short sequence of events, my lord.
Yes. Yes.
Lord, may I just point out the facts, my lord? My lord, the original first row, my lord, the original advertisement of October 2007, my lord. On the first page of my note, my lord.
Right.
In the table itself, my lord.
Right.
Original advertisement is of this date, my lord. 10 years the advertisement was pending. Then 2017 we restarted the process, my lord. And while restarting, we said that there will be 4 posts. Original post was 6, my lord. Then, in the meantime, the selection process already started. We received 67 eligible applicants from old advertisement and 100.
Then you issued the corrigendum on 2nd of August.
My lord.
Yes.
So, my lord, all these things happened, my lord. Now the selection committee, after 6 posts were published by corrigendum, my lord, the selection committee says that you reduce it from 6 to 4 and the remaining 2 posts will be re-advertised, my lord. Then the correspondence with the ministry said that you go by the recommendation of the selection committee. So that is where we are, my lord.
Is
Now
not that also, is this like, if the other 2 posts are there, what is the necessity of saying re-advertise the other 2 posts? If the corrigendum corrected that first advertisement said 6, second said 4, corrigendum issued to say again 6, then the petitioner came within the zone of consideration and select list, he's within the 6.
Well, that time he was within 6, my lord.
Of course.
But now he is
and
within
then
4 also, my lord.
He's within 4 also. Forget about that. But then the thing is that now whether selection committee can sit over the corrigendum now. It cannot.
It cannot.
Then it ends there.
So, my lord, only what I was trying to point out, my lord.
Yes.
At page 3, my lord, lords will see.
Nothing else, Dr. Mida, enough.
No, my lord, what I am trying to submit, my lord, that petitioner is submitting, my lord, the first waitlisted candidate is not interested anymore, my lord.
We would be aware of that.
So we do not know, my lord. We don't have any official communication to that extent, my lord. So lordship passes an order that to consider whether the first waitlisted.
But resignation from a post, that doesn't mean that, any you can accommodate by the waiting list. There'll be fresh advertisement against that after they've joined.
My lord, the first waitlisted has not joined, my lord. He got some other job somewhere, so he's not interested. That is what the submission is made. But this communication is not there with us, my lord, officially.
So, my lord, my prayer that respondents can reconsider the matter in the light of the fact whether wet listed number 1 is interested or not.
My humble, respectful submission. My lord, what very important matter which is before this honorable court, my lord. Whether
the action of the respondents is arbitrary or is it justified, and whether a direct mandamus can issue to order for your appointment.
No other aspect, my lord.
Right.
Whether the selection committee can revisit, my lord. That's a very important matter, my lord.
Yes.
No, as long as he is within 4, my lord.
I understand the line of submission is that without muddying the waters.
My lord, if he gets, my lord,
we will pass orders today itself.
Main list item 22.
We have already submitted our written bullet points. The matter was pending. The connected matter, my lord, by
I'm praying this matter can be taken up at the bottom of the list, Mr. Paul, please.
What, Mr. Paul? Because actually this matter was finished. We had heard that, but you said that the similar matter. That is why this matter has been lingering. Okay, list after 1 week. We'll give you ample time to Mr. Paul also. We have to refresh the court. The matters kept pending, have been kept up pending for no reason, because just on your request.
23. 23.
my lord.
23.
It's
connected
1 week.
22, 23.
26.
May it please your lordship. This is a matter regarding publication of photograph and notice in the newspaper as a will showing the.
Why are you doing the screen? Mr. Paul is supposed to magically appear there and save the day.
To be, no, not exactly, my lord. He was supposed to be leading us today, my lord. Since he lost the connectivity, I do not know. Otherwise, we have
Actually, this matter can be dismissed, your lordship. The publication was made in the year 2019. 4 years have passed by. What is there to recall and what is there to quash, your lordship?
Still consider whether the action was at all within the four corners of law, my lord, and whether they really followed the procedure while.
What do you want, Mr. Thapa? Vindication?
Yeah,
Not exactly, my lord. But
Then?
No vindication, my lord. But
that's vindication.
Least, my lord,
who remembers the photograph newspaper now?
Of 2019, 4 years.
They are the banks, my lord. They are expected to at least act in with some kind of a.
We have acted, your lordship. We have got
because here, my lord, this particular proceeding, my lord.
Okay, after 1 week,
notice.
Please be ready.
Oblige, your lordship.
Let you absolutely Mr. Cape on this matter for 1 week.
27.
Mr. Paul was supposed to be here.
No, but it's a matter of division bench, this one. It's pending, yes. Yes, Mr. Nauri.
After 1 week, consider the DB
Matters
also
over.
leading nowhere. The policy matters leading nowhere.
But DB matter is coming on 18th of June, 18th of July, my lord. So this may come after that, my lord. The 3rd week of July.
This is only a tender process. They'll have a direct bearing then. If that matter is settled, then
yes,
it's going in whose favor? Still a draw now.
So one day this side, the other day that side.
Okay, on the prayer, the party, the council will submit that the connected matter is still pending disposal for the division bench. According to this matter after 18 July for further orders, yes. That's for hearing, sorry.
28.
Yes, my lord. In this matter, my lord, there's no FIR against me. FIR has been withdrawn, so there's no case.
I don't know what are the facts of the case here. Argue as if like I know all the facts at my fingertips. Give this court a break also.
My lord.
Yes, what is the matter about?
My lord, this matter is about this. There's a lady who was under. If you can refer to my affidavit, everything is there, my lord. I'll read accordingly and.
You're a petitioner?
Yes, my lord.
Who were the counsel appearing here before?
Earlier, Mr. R. Gurung was the counsel for the petitioner. R. Gurung, Ravi Gurung was the petitioner. Thereafter, they have changed the counsel.
What is the matter about?
Yes, my lord.
It is regarding this small savings scheme, your lordship. She was the agent, and she has withdrawn some money from the client's customer's account. So regarding this
What is
FIR,
the prayer? Yes, come, Ms. Bang. What is the prayer in the minute
The prayer
petition?
here is to renew my to give me a new license. My lord, I will read the writ petition. The prayer is at page number. I'll show you. So yeah,
Page 8.
page number 8. Sure. 1 minute, my lord. My lord, if we could refer to my affidavit, my additional affidavit, wherein I have written everything, my lord. Where I have explained this case at length.
See, Ms. Bang, we start from the pleadings you make in the minute petition.
Yes, my lord, but
Everything
this,
comes in addition to and
right, the prayer is at the writ petition at page number. Yes, at page number 8, my lord. The writ petition is dated 29 September 2021.
yes, yes,
Shall I read it, my lord?
yes.
The lordship may be pleased to admit this petition, issue rule upon the respondent to show cause as to why the writ of mandamus or any other appropriate writ, so and so, so and so, to directing the respondent number 5 to allow the petitioner to make deposit forward with continuously, and further directions against respondent number 3 to renew the license of the petitioner for
So
3
where
years.
what situation right now?
The situation right now is that the FIRs have been withdrawn against me, my lord. If you can
No,
find
no, no. This situation is what are you still continuing your agency?
No, my lord.
Yes, and number 2, what deposits are those? Have you still making deposits
Yes,
on
we
behalf
have
of people?
deposited, but we were not allowed. There was a contempt petition, but then the contempt petition has been disposed of because I was not allowed.
So what is the situation right now?
The situation right now is that I have no job. I'm nowhere. So the
Where's the additional
the
affidavit?
additional affidavit is dated. I will tell you, my lord. Dated 27/3/2023. I will go serially, my lord, to explain to you.
Yes, go slowly. No need to hurry.
Yes, my lord.
Yes.
Thank you.
Collect your thoughts and your case.
Thank you. I begin at page number 3, my lord.
Yes.
So at page number 3, this is a scheme. The scheme is the Mahila Pradhan Kestriya Yonya Rules, 1972, wherein I collect, it's a scheme for recurring deposit accounts of 5 years. I have been given a contract of 3 years. I have continued as an agent for 12 years. Right, my lord? So, as per rule number 9A, which is very important, my lord, at page number 4, rule number 9A says that, if I may read just a relevant portion, that the agent cannot act as an agent or messenger of the depositor for the purpose of withdrawing any money. The allegation here is that, my lord, that I withdrew money of my client of 12,000 rupees. That is the only allegation against me. Point number 4 is the many years that my contract was renewed. Paragraph 4, for 12 years.
What's happened to the FIRs? Were cases
The
registered
FIRs
and
were
they didn't
withdrawn.
file the report, or what happened?
My lord, if you jump to paragraph number 17, I will show you, my lord, wherein the complainant suddenly withdraws her complaint. Page number 14, thank you. If I may read, my lord.
You resolved it amicably.
Yes.
Yes.
So there's no allegation.
So then we'll dispose it off. Yes.
And my lord, but the request is that because there's no allegation against me, nothing has been found against me. I have not withdrawn the money.
When you
My
file a
lord,
case of malicious persecution against the people who lodge a FIR against you, take down.
Yes, my lord. My lord, if my contract may be renewed then.
Yes,
for another 3 years.
Response submission.
oh, you're there, sorry. Yes.
My lord, the petitioner, this is dealing with public money. My lord. She is collecting money, maybe against one complainant, my lord. She has settled the matter, but in my humble submission, because she is handling money on behalf of interested to her by many people, my lord. So, my lord, some kind of, in my humble submission, looking at the antecedents of this petitioner, my lord.
Yes.
Only because this complaint has been settled, my lord, and that has been settled between inter parties, my lord. The complaint.
The court noted that.
My lord.
The court noted that it's settled amicably.
So, my lord, permitting her again to deal with public money, my lord, in this kind of circumstances.
Who is the authority to renew license? Is the Director of Small Savings?
Yes. If I may reply to your point, my lord,
Yes.
at page number 26, paragraph 42 of my additional affidavit, I have 470 clients, my lord. There's no complaint against me till date. I deposit every month 8 lakh rupees. And till date, my lord, there's no, I give revenue to the post office.
Okay. Take down this writ application has been filed with the prayer to issue directions to respondent number 5 to allow the petitioner to make deposits continuously, and also against respondent number 3 bracket Director of Small Savings to renew the license of petitioner for 3 years as per the rules contained in the scheme known as the Meghalaya Pradhan Kshatriya Bachat Yojana rules, which is annexure 1 of the writ petition. Stop. Next paragraph. The petitioner who is stated to be an agent under the scheme mentioned above has been the holder of a license issued by the competent authorities since the year 2009. Stop. However, it appears that due to certain events that transpired with regard to the deposit of the amounts, where is the impugned letter whereby your license not renewed?
Yes, my lord, I will show you. My lord, it is at page 21 of the counter affidavit, annexure 7, dated 28/4/2021.
Whose counter affidavit?
Counter affidavit of respondent 5.
Annexure?
Wait, no, my lord, that is the statement. Annexure. Wait, 1 minute, my lord, let me verify.
Where is it?
Might show you.
Where's the whereby she was not renewed?
Annexure 5, your lordship. Page 12 of my affidavit.
Page?
Page
What affidavit is yours? Respondent number?
3.
Number?
Respondent number 3. Director of Small Savings.
Page 5.
Not annexure 5, your lordship. Annexure 2 is the notice of cancellation at page 8, annexure 2.
Due to certain events that transpired, deposits, a notice was issued on 6th April 2021, bracket annexure 2 to affidavit of respondent number 3 for cancellation of the petitioner's license on the basis of a preliminary inquiry where allegations of illegal withdrawal of money was established. Stop. The writ petitioner also directed to show cause for the said notice of cancellation, which was duly filed by her, also, which was duly replied letter dated 15 April 2021. And where's the cancellation? Where's the cancellation?
There is no.
Stop. Not okay. Subsequently, it appears by the letter dated 20th September 2021 by the respondent number 3, bracket annexure 6. The license of the petitioner was renewed provisionally only up to 15/10/2021. Stop. Being aggrieved by the non-renewal of a license and also the non-acceptance of the deposits from her clients, the petitioner before this court. Stop. I have heard legal counsel for the parties. MS Bang, who is a newly appointed counsel on behalf of the writ petitioner, has drawn the attention of this court to the additional affidavit filed on behalf of the writ petitioner on
My Lord, 27/3/2023.
23 27/3/2023. Showing the factum of withdrawal of an FIR wherein allegations have been made about wrongful or about illegal withdrawal of money from the account of one of the depositors. She submits that the petitioner has been put to great harassment as much as she has been all along since the inception of the agency worked in a bona fide manner. Stop. What do you have to say? She therefore prays that the respondent be directed to renew the agency of the petition. Respondent number 3 be directed to renew the license of the writ petitioner to enable her to function as an agent under the schemes, authority scheme. Yes, what do you have to say?
Yes, some time frame may be given because.
Yes, MS Barachaji on behalf of the writ petitioner submits that at this stage no further submissions are necessary, but only the fact that the proceedings that had been entered into earlier were on the basis of the serious allegations that had been made against the writ petitioner, inasmuch as she's handling the money of small depositors who expect genuine returns. Next by Dr. N. Mozika on behalf of respondents number
5.
5 has also concurred to submissions made by the learned GA and submits that in the event of any consideration being given, the antecedents of the writ petitioner have to be examined afresh.
One additional submission. In our affidavit, we have annexed some letters from 16 of her depositors, my lord, who want to deposit directly with post office without going through her.
No, the antecedents will look, yes, and the antecedents and manner of functioning. Next paragraph. Having heard the counsel of the parties, this court an examination of materials and record, or after having heard an accounts of the parties, after examining the materials as placed on record, this court, especially on the fact that the initial cause of action which had warranted the proceedings against the petitioner not being existent on this as on today, though the settlement or withdrawal of IR was occasioned by a mutual compromise between the complainant and the writ petitioner, in the interest of justice, it is directed that the respondent number 3, on an appropriate application being made under the scheme by the writ petitioner, shall consider the same within a period of 2 months from the date of such application. Next paragraph. As submitted by the counsel of respondents, it is important also not to lose sight of the fact that at the time of consideration, the respondents shall consider all aspects of the matter, especially as to the conduct and manner in which the writ petitioner has managed the her agency on earlier occasions. With the above directions, matter stands disposed of.
3 months time may be granted.
Yes?
3 months time may be granted for renewal because it is subject to deposit.
What does the rule say?
Rules, nothing is there. Rule is not there, but your lordship, since there is some investigation and inquiry, respondent number 4 is the head office here. Your
2 months more than enough. Yes.
36.
Relates to seeking for transfer from the case.
Oh, Mr. Barasaji has serious objections to about. He said that regarding the judgment, correct?
Well, for me, this is a matter which is squarely covered by division by judge.
Yes.
Now, how to distinguish it? Let me just.
Are you ready today?
From my side, I'm okay. Apart
Who are the parties involved?
Sir, Kenjing is there. Sir, Kenjing also, senior counsel. She is also ready. My humble submission is that London Division Bench judgment is not covered.
So that is what exactly. That is why we put all these matters together. Yes.
May I just take one? Let the senior depend.
Yes.
Your Lordship, this is a petition for transfer.
Yes.
In this case, whether the.
Let's go to the division bench judgment first.
The division bench hearing, judgment.
No, you seem to distinguish that. Your submission is that the judgment of division bench will not cover your case.
No,
correct.
As far as division bench is concerned, my lord, the division bench has, because this is a case in which they have said that it's from River district, number 1. And number 2 is that it is disseminate on merit. It's not a petition of transfer, my lord. It's a disseminate merit, that one, that division bench order.
But has it touched upon the factum of jurisdiction?
Well, as far as factum of jurisdiction, my lord, I entirely depend, as far as my petition is concerned, I entirely depend on the decision of the Honorable Supreme Court in which I have already laid down my.
That Justice Mukhopathyay's judgment. Correct?
No.
No. Anyway, okay, please.
This is referring to some other.
Yes.
As far as division bench is concerned,
you give the list of. Have you given list of books?
No, but it is already enclosed, my lord, in your petition. Already enclosed. Annexure 4, my lord.
Yours is Sri U. Kumar Yoran.
No, my lord. Hamish Banchan Board's aim.
My lord, since there are series of cases, I am appearing in two of the matters. So far as the factual aspect of this case is concerned, I may not know much, my lord.
No, but who's appearing?
If it is only on the points of law, my lord, then definitely.
Point of law is Chairman.
No, let's have Mr. Kinjing's writ application.
CRP number 1, my lord. It's CRP number 1, my lord.
Hame Banshambor.
Yes, madam.
Okay.
Because as far as that decision of our division bench is concerned, my lord, my contention is that division bench order, my lord, deal with matter on merit regarding that the particular case filed by my learned friend in that case.
It was the judgment of division bench. No. Mr. Chandra, so kindly given a copy. Yes.
So, whereas my petition, my lord, I base on the decision of the Honorable Supreme Court that the matter which is as per notification issued by the government, it has to be transferred to the district council, my lord. Because, as per that notification, my lord, the cases which involve the tribal are to be determined by the district council. Because this court have been established, my lord, as per constitution under paragraph 4 and 5, my lord. Conferment power is true, my lord. Conferment power was given to the AGC also. I didn't say that AGC doesn't have the power. He has the power. But the only thing is that as per the notification of the government, it is to be determined by the district council, my lord. And that's why I rely on this judgment of the State of Meghalaya versus Melvin Sorang Piao 2020, which you are fully aware also. So, in view of that matter,
That is her judgment. That is, yes, that is her. Is here in the petition?
Yes, my lord. Annexure 4, my lord.
Now CRPC is applicable.
Yes, my lord.
Then how does it change the complexion of the case?
That's why, my lord,
No, see, now we are different. We've gone one step further from the sort of your judgment. If I'm not wrong, that's the only thing. We have to look at it from a different perspective now, in the sense that if CRPC was not applicable totally, now by notification which has been accepted by the entire state, also it's been extended. Correct? That was done last year, I think.
Yes.
So now that changes the dimension of how you appreciate the adjudicatory powers of these who have been vested with the powers, like learned additional to deputy commissioners' courts also.
That's why, my lord, I have submitted that I didn't dispute that the AGC also has the power. Once the governor has.
But he's taking primarily to paragraph 4 to say any dispute between tribals has to be settled with the council court. That is your primary.
That is my
primary contention.
Yes. Because they also have been conferred with power, so of course it's.
No, Jayante Hills has not been conferred with power. It's by persona designata. What happens to 302 matters, transportation for life above 7 years in the Giant Hills? It goes to the regular sessions court.
Yes, yes.
Then, because your argument will be wherever the district council judges have been conferred with such powers, it is incumbent that those matters should go straight before the district council court.
Yes, madam.
Let's see the Solanpur judgment. Is it? So let's see the division bench judgment first. You say that it is directed. It is confined only to the facts of this particular case. It's not the judgment in rem.
As far as the division bench concerned, it's only for the further case which was determined on merit regarding it's not regarding that transfer to the district council and other matter. Because that is based on merit.
You look at para 2 of the judgment. You see, from para 1,
yes, ma'am.
we'll do one thing, Mr. Kinjing. So we will please come prepared. I mean, with your support notes and all, we'll fix a specific day. Then the court also on its own will go through the matter.
I don't know. This unnecessary issue has been. If this Merlin case will not apply here by proposition of law, will not.
Which one?
That the 2020 SCC minor, which has been referred, that will have no application here.
You pick a date, Mr. Kinjing.
Lordship may give a date so that we can.
At least you come fully prepared, so we don't waver here and there, not anything.
Of course, we have
and assist the court also, yes.
Limited to submit also, because that's why.
There's no limit to submissions here on this point, Mr. Kinjing. It's so interesting and fascinating.
No, my lord, what I was looking for, how senior counsel my lord distinguishes his case from the division bench judgment, my lord.
That is what that was on the main plank on which all these transfer petitions were put together. That this division judgment will not apply to your specific cases, to your cases. That's the thing.
Because why it doesn't apply, matter? Because my contention, matter, is that it deals with the merit of the case of Nongpo case, my lord, and this case is from Nongpo, whereas
Nongpo comes under the same district council code.
That's true.
Then,
but the thing is that the way the honorable division bench, matter, it deals with the regarding that merit of the case.
Has anybody appealed against this order?
Of course, there's nobody appealed.
I don't.
Nobody appealed.
So it's accepted.
Nobody appealed.
You take a date. We just will have it. At least you tell your juniors to at least do some work. When you assist, you should assist in a proper manner. Yes, Like for the juniors, they should go. You should also, dive deep into this matter. The concern is every day is a everyday affair for us here. And like for local lawyers, we should dive deep into this. There's one area that's very lacking, especially in jurisdictional issues that come before, like when you're practicing also before the trial courts, with regard to which court have jurisdiction, whether it comes under what rules, whether it's 50, 37, 53. A lot of juniors have not been properly instructed out there, so a lot of errors are made. It's not their fault. Also, it's just that there's not much interest now in in like really coming to grips with the matter from the bare bones. It's just everything so superficial that you won't find, like for these kind of matters, you won't find help on the net. That's all. You just have to apply your mind. I mean, I'm telling the juniors. It's very interesting. We live in an area with a 6-schedule state. It is like it's a preeminent piece of legislation which affects our lives. You take a date, we'll fix it when. I won't. Second.
After we give lordship permits.
We'll fix it on 11 July.
11th July.
Yeah, because before that there might be some programs. Yes.
Supplementary list 1. Item number 1.
Ideally 11th. So who's the Nokma who's in danger?
Lordship, the petitioners, my lord.
Who is the challenger to the Nokma?
Lordship. Lordship, in this matter, what has happened was like the petitioners were appointed as Nokmas by the Chaz and Maris, my lord. But before they could...
One second. Let me just... The petitioner was what? Which... One, let me just look at synopsis. It was never filed again before this court. After it's withdrawn.
It is being filed now, my lord. This is...
No, I mean, see, what happened was, you said that this is this what is?
Gauragri Akhang.
Gauragri. The spelling is different. It's the same Gauragri Akhing. Anyway, Gauragri Akhing, that you are the rightful one, the Chraz and Maharis have selected you. And then, but respondent 5 and 6, they have gone and they've made an application. He never appeared. The matter went ex parte, as per your thing. We didn't file a statement. Then you file, you prayed to allow, it was rejected. Then even for the CEM, which was also
rejected.
Which was rejected. And then you came for this court, you withdrew the petition. What happened? You didn't never file a fresh one.
No, the petitioners actually, my lord, they were not keeping well, it seems, my lord.
From 2019. When was the matter disposed of by this court?
It was withdrawn in the year 2022, my lord. September 22. September 22, my lord.
Who's LD Sharma?
LD Sharma.
Why you didn't file again?
Lordship, that is where I'm coming to that point, my lord. I've been instructed that they were not keeping well, my lord, for quite some time, so...
From September till now?
Lordship, that is what I've been instructed, my lord.
Where's the medical certificate?
I've not enclosed, my lord, but that's what I've been instructed.
How do you support a submission that they prevented from coming to court? The coming as ordered is 2019.
Lordship.
Where are you saying, where is the, you're saying that today they're going to register them, where is that?
They said that the date was fixed today, my lord.
For what? For registering them?
For registration, my lord.
Now what right survives? That is all stand extinguished from the first round of litigation, first round when 5 and 6 went to get the names registered.
Lordship, but they have not been appointed as yet.
It doesn't matter, but where's the urgency, Mr. Moomin? You'll have to wait for the outcome.
Lordship, I'm just praying that if an observation may be coming up from this honorable court, my lord, that during the pendency of the matter, at least
it won't be fair. It won't be fair. If people have gone before the court, you've been negligent. In the appeal, you've been negligent. Also, you came and withdrew it. Whatever it is, you have to.
It was withdrawn because of formal defects, my lord.
Doesn't matter.
Some of the orders were not enclosed.
Doesn't matter. And then you have not shown anything to say that yes, like today has been fixed for appointing them as Nokmas.
That is what I've been told, my lord. That a date has been fixed today for appointment.
We'll issue notice, that's all, but that is not urgent. Heard Mr. E.G. Moment, then a counsel of the petitioner. Issue notice, Mr. S. Deb, Vice, Mr. Are you standing counsel also, Mr. S. Deb, now? Still just imposter type?
Not sure.
On behalf of Mr. S. D. Yes, Mr. S. Deb, Vice, Mr. S. D. accept notice on behalf of respondent number.
1, 2, and 3. No, 1, 2, 3, 4.
No, that is
1, 2,
1,
1, 2, 4.
1, 2, 4. Yes, issue notice by respondents. Though this writ petition, though the petitioners had withdrawn the earlier petition, namely WPC 28/2019, which was allowed by order dated 26/9/2022. Have only filed, which was allowed to be filed afresh by order dated 26/9/22. Have only today offered instructed petition. So, just after 3 weeks for instructions.
Lord, I'm just bring for an observation.
No, nothing. Sorry, Mr. Moment. Can't put other people to stress for nothing.
Item number 2.
Hello, Blashman.
What is this, Mr.
VP's Lordship. Lordship, this there's an auction seal notice was floated by the DC, Ribhai District, Your Lordship, which is
first notice.
Auction
where?
Auction seal notice, which is at page 104. Sorry, Lordship, at 102, Annex 18. I became aware of this notice on Monday, Your Lordship. And Your Lordship, may I refer to page 103. The urgency here is that for the tender will be conducted on Monday, Your Lordship. And my unit is a stone crushing unit.
When's the auction date?
26.
No, this is for receiver bids. Last submission is 28 June.
At page 06, the inspection of property can be inspected.
No, that is fine. Last inspection is on. Have you wrote to the Deputy Commissioner?
No, Your Lordship.
Then you take it, go and
Your Lordship, the major point, let me enlighten Your Lordship on the fact of the case that, we can refer to page 112, Your Lordship. I was categorized and classified as an illegal stone crusher at page 112.
Yes. You're not aware
my
of that.
serial number is at number 22.
Yes.
Which is at page 115. Your Lordship.
What's Dalin Rose Namshi?
Yes, Your Lordship. And Your Lordship, let me brief Your Lordship on the facts on why.
Very small crusher plant, screen 3 makeshift tin channels, assembled DG7 truck engine, makeshift control room. This will be worth only 20,000-30,000. Why you worried?
No, she has invested a lot, Your Lordship. She has invested a huge amount of money.
Were the proceedings against you under the Air and Pollution Control Act?
Yes, Your Lordship.
Then what happened to the proceedings?
It's still pending. And even they
pending
have...
where?
Pending before the Chief Judicial Magistrate.
No. I'm talking about the proceedings before the authorities, Pollution Control Board.
No, Your Lordship. Your Lordship,
Where?
let me brief on the facts, Your Lordship, because at first instance when we have the setup was established, it was under the Industrial and Investment Policy 2012, initiated by the Government of Meghalaya.
You have the consent to establish, consent to operate.
Yes, Your Lordship. At first instance, Your Lordship, we have a registration of the stone crushing unit, Your Lordship, which is at page 24.
Okay, let's go slowly, we've got lots of time. 24.
Yes, annexure number 2. Is hereby registered under the Central Capital Investment Subsidy Scheme.
No, this is not important. 24. Show me the pollution control clearances. The consent to establish, consent to operate.
And Your Lordship, prior to, we can refer to page 62. This is the certificate, eligibility certificate, issued by the Directorate of Commerce and Industry to set
Who's
up.
RSM Stone Crusher?
She's the proprietor, Your Lordship. The petitioner, I'm the proprietor of the unit. And the date of commencement of production, as per the document I'm relying on.
Sure, those two documents. See, I'll tell you one thing, sorry, Mr. Lindo, but this court has dealt with many of these matters. Vipa judgments also, all those Wesley, Dalloy, and this and that, many cases, they've gone up to Supreme Court also, they have not. See, the thing is that now, if you're operating a stone quarry, you have to have valid permissions.
Yes, Your
And
Lordship,
you
I
have to
have
know how much the output. Where's the valid permission?
Annexure number 7, Your Lordship.
Come to that first,
Annexure
please.
number 7 is the consent to operate.
Let us see. Where's number 7?
At page 63.
This is 2016 one.
Yes, Your Lordship. I'll come, Your Lordship, to that. And Your Lordship, the first consent to operate was issued in the year 2015.
It has limit. It should be. Should
has
you
to
have
be-
a valid, subsisting permission to operate as the date when proceedings are taken up against you?
Yes, Your Lordship.
They've not had one for the past
Your
5 years,
Lordship.
Lordship.
Annexure number 8. Annexure number 8 is the receipt which I have paid for renewal of the consent to operate, but I was never issued the copy of the consent to operate. And
So as on date, that means you don't have any operating license.
for the reason concealed by the Pollution Board, Your Lordship, we did not receive. But we have already made payment and they have acknowledged the payment of the renewal for the CTO. Your Lordship, the CTO, they are valid for 1 year, Your Lordship.
Yes.
And for 17 we applied for, we did not receive the consent to operate.
What about this letter, Annexure 10, Mr. Lingdon?
This, Your Lordship, they have sent a notice for that I can procure raw materials to use in the unit. But the fact here, Your Lordship,
It says here, subject renewal of consent to operate matters thereof.
Your Lordship, but I have the receipts which I have.
No, I
have
mean,
approached the-
why did it, if they already said renewed your consent to operate, why did they renew it further? What is the reason?
That also we have inquired, Lordship, but they have remained silent on that. We did not get any result. So, Your Lordship, then in 2019, when we received this document in Annexure 10, Your Lordship, they
You got a
have.
notice also in 2021. It's under 33A of the Water Act.
Yes, Your
and-
Lordship.
Yes.
And then, Your Lordship, we have filed an application dated 29/7, which is Annexure 12, for concession of the environmental compensation imposed. And Your Lordship, again, another letter was issued on October, which is Annexure 13. And subsequently, Lordship, then the Meghalaya Stone Crusher Order was passed. It was published.
Yes.
And Your Lordship, here at clause number 6, Your Lordship, the legal source of boulders. Your
What
Lordship,
about this order dated 28 October 2021, Annexure 13?
20th October, yes, Your Lordship.
Yes.
Then, Your Lordship,
Have you challenged this one?
yes, I'm challenging, Your Lordship, informing the court on the issue of why.
No, you just, okay, we'll just come to page of your provision, page 20. You read it.
Your Lordship, page 70, Annexure 13.
70, yes.
Yes. Whereas the board received information upon a committee constituted by the AGT and so, that have been operating stone crusher in violation of the term condition of the consent to operate from the State Pollution Board without applicable clearance. Physical inspection conducted on the committee that stone crusher was found operating, and no requisite permission for operating the same was provided to the inspection team on the site. And so on. And Lordship, the show cause.
See this one, the stone crusher is found operating to open without any measures for control of noise, air and water pollution.
It's false, Your Lordship, because
Now you see, there's one basic thing in these matters. What is that basic thing?
Consent to operate.
No.
Established.
You have an appeal provision.
I beg your Lordship.
You have, where you have to go if such orders are passed against you.
We have to go before the board.
You have to go before the National Green Tribunal.
But there's an urgency here, Lordship, because of the issue. But, Your Lordship...
this was 20th October 2021.
But, Your Lordship, here, it's because subsequently, after issuance of this letter, they filed a CR case against me, Lordship, which is at page 15.
CR case will have no bearing, it's like on...
But, Your Lordship...
Water Pollution Control Act.
Your Lordship, before coming to Annexures 15, I would like to bring to your knowledge, Your Lordship, I can refer to page 76.
Okay.
Pollution Board is having supervisory power, Lordship. May I read?
Of course, they have supervisors.
But they did not go in accordance with the order.
See, the thing is that you have avenues for appeal. Okay.
We weren't aware of the entire case, Your Lordship.
See, the thing is that, see, Mr. Lingdo, you're operating a crusher unit, right?
Yes.
You're operating crusher unit, that is in the year 2021. They did an inspection. They found that you're operating without a
But we
consent
will not
to.
serve any notice, Your Lordship, for the inspection as well.
They gave you in 21. They gave this in 21. This is order passed. It's like nearly 2 years ago.
Your Lordship, they say
What?
the inspection was in 2017 when I'm already having a valid consent to operate at that period.
Then why didn't you appeal against this order?
We have approached, Your Lordship, the State Pollution Board.
Yes.
Your Lordship, may kindly refer to page 99, which is Annexure 17.
Now, 1 second. See, you look at section 31 here. Against the 21 order, this is your forum. Court's not to advise you.
Your Lordship. Your Lordship, the
So what happened to the CR case?
in the CR case, the matter is still pending, and yeah, Your Lordship, during pendency of the matter, even the court advised that if there's any chance of settlement, because initially there are CR cases, other which has been filed by the State Pollution Board, that some concessions were made.
Then you approach them again.
We
You
have
still have
approached, Your
time.
Lordship, that this is Annexure 70 when I approached, Your
17?
Lordship, at page 99. Until present, since January that we have filed, Your Lordship, there's no response. We have enclosed the drafts and the letter that we have sent previously on 2021.
This is not a representation against auction.
No, this is a letter which I have sent to the State Pollution Board, Your Lordship. Annexure 17. They have duly received on that date. So
No, this is intimation. See, read what you say here.
Yes, this is in respect to the annexure for.
It has no nexus with the writ petition, but you've come here before regarding the auction.
I beg your pardon, Lordship.
It has no nexus, means no connection with the let's see what prayer you made in the writ petition. You've seen the appeal provision, correct?
Yes, Your Lordship.
You didn't take any recourse to that appeal when 21 order was served on you.
Your Lordship, the petitioner came to me at a very late stage. I'm sorry.
I'm not saying you. You means, I'm not saying you, Mr. Lingdo. I'm saying you means your client.
Yes.
Yes, you're standing here.
Yes.
You're not the quarry owner.
She's an illiterate lady, Your Lordship.
So that is what.
So with no educational background, Lordship, she's approaching the office.
She's running a quarry. She has no educational background.
No, it was run by the husband. I have made statement, Your Lordship, in my petition, paragraph number 2, number 4.
Your prayer is very big also. It's only against the auction, and this representation has no nexus with the auction.
Your Lordship, the respondent number 3, which is the Pollution Board, will be best to answer before the application.
You have no time. 28th is the last day. 28th is, you have till Wednesday. You can file before them.
The pollution bond.
Yes, you go for
We have
pollution bond.
approached them.
Yes, you don't approach them against the auction. Where is it?
Because it has been published by the DC, the Deputy Commissioner.
Exactly, you go to Deputy Commissioner also. If this court will not interfere at this stage, because you've been absolutely negligent with handling your case. Because you see, you have a prison appeal. If the 21 orders issued against you, whereby you've been found to be infraction of section, I think, anyway, of 31A and this and that of the Air and Water Pollution Control Act, remedy for appeal is there. Yes. If you feel that yes, that you have genuine grievances that it was renewed and you could not obtain raw materials from somewhere or whatever.
Your Lordship, with respect to that, the order also has specifically stated.
See, at this stage, Mr. Lingdo, you still have time. Take down administrative petition has been filed seeking anything to say.
My lord has said it all.
Yes, seeking appropriate orders to suspend the auction sale of the petitioner's crusher unit, which has been notified by the impugned letter dated 7/6/2023. Stop. Where is the order? Page 7/6. Which page?
102. Page 102. Further, Your Lordship, may I make submission because in respect with the regulation 1886, Your Lordship, there should be compliance of section 68 also is
regulation of
the Assam Land and Revenue Regulation. They have issued this under section 69.
So that comes auction stage. That is not.
Your Lordship, but I was not issued with a notice of demand or notice of to clear whatever areas in default.
This is only for regular payers, Lordship.
Yes, Tom.
I was not in default of any of the tax.
No, it's not that. See, the question if it's a recovery. So recovery, there are different proceedings for how do you recover to recover penalty amounts. So you have, in other states they have a special act supposed for like electric consumers, correct?
Yes.
So they don't pay their bills. Now you see many cases appearing in this court, like all these industries, especially Mr. Thapa's clients, they avoid paying, because they don't factor in electrical costs as an input that they have to service, correct? Yes. In other states, they don't have this problem because they have a specific, sort of an act which deals only with recovery of power dues. Yes. That means, and this act is really, it's very draconian in nature, in the sense that suppose they don't pay, they can seize your pots and pans also to realize the amount. So out here we have that Bakijai proceedings, right? So this is also a manner of recovery of of dues for infractions that you committed. So that's the only thing. Doesn't mean the regular revenue payer. It's not a question of paying on revenue land that you're paying regular revenue. That's not the case. The case is that it's only a mechanism by which they will realize the fine amount. That's the thing. Yes. So, Thomna?
This petition has been filed seeking appropriate orders to suspend the auction sale of the petitioner's crusher unit, which has been notified by the improvement letter dated
7/6/2023. Stop. The petitioner submits that though renewal for the consent to operate had been filed before the Meghalaya State Pollution Control Board, that is respondent number 4, they were not favored with the same, and in where's the 21 order? Yes.
Page 90.
And yes, and 70, and the respondent number 4 had on 20th October 2021 passed an order establishing the fact that the crusher unit was operating illegally and such, which was in contravention of the provisions of sections 24, 25, 44, 45A and 47 of the Water Prevention and Control of Pollution Act 1974, as well as the Air Prevention Control Act 1981. It appears that no appeal preferred against this. It appears that no appeal has been preferred against the said order, but however, there is also the presence of a CR case, CR proceedings instituted by the respondent before against the petitioner, which the Learned Council submits is still pending. Next paragraph. MSNG Shiller, Learned Senior Advocate, submits that the writ application is not maintainable in this form, in as much as the petitioner has failed to assail the basic impugned order, that is 2021, wherein an appeal is provided under the Air and Water Pollution Control Acts before the National Criminal Tribunal. Stop. It has been further submitted that, what further submission do you have? Nothing else.
No, Lordship, with regard to section 68, is only for regular pays. That is explicitly mentioned.
She further submits that the auction has been notified under the Assam Land Regulation, as it is only a mechanism for recovery of the fine amount which has been levied upon the petitioner. Stop. I've heard the counsel of the parties. After hearing the counsel parties and examination impugned order, it is noticed that the auction notice dated 7/6/2023. Where's that page again? Sorry.
102.
Has invited for sealed tender bids from intending purchasers in the prescribed format to be deposited by 26 June up to 5 p.m. and the last date for earnest money deposit and application on 28 June 2023 before the Deputy Commissioner, Ribhoi District.
Please, at page 104, the auction schedule, the date and time, public opening of bid is mentioned as 26 June.
Where is that?
At page 104.
Then how will the auction notice and the thing be different? Oh, right. Yes, you're right. 26 is Monday.
Yes.
Where's the auction sale notice in the paper? This one. So I thought, no. Yes, I'm sorry, 28 here, so. Yes. As you should have come earlier, this is 7 June. In the interest of justice, however, the writ petitioner is permitted to file an representation before the Deputy Commissioner with regard to the auction of the properties, with the operation of the quarry stone crusher unit of the petitioner on the grounds as set forth in the petition. Stop. This court, however, thus is not preventing the process of auction, but only to direct the respondent number 3 to withhold the settlement of the auction till disposal of the representation of the petitioner. Let them have a look at it, let the auction go ahead.
Lordship, there is some form of state with respect to my property as per the serial number.
See, auction's already gone 26. They'll have the auction. They'll keep it in. I think I'll correct the order. Keep it sealed, and then let finish out the explanation in 1 week and finish.
The petitioner has already sealed.
See, you can't stop these people. They've already put in there. They have legitimate expectations also.
Yes, Lordship.
Whatever state your quarry.
Let it be protected, Lordship, like in
We'll pass order. I'll correct it. Yes. The court will embellish the order. Yes.
But this is all in compliance with the NGT directions, my lord.
It's only that let him give a chance just to air his grievances.
Yes.
Which we're not making observation. You had issued of appeal long time ago, 21.
Yes.
If we had a genuine case.
Lordship, as I've already stated in my petition as well.
See, the earlier petitions that filed before this court, they suppressed a lot of material and heavy costs inflicted. You must be aware of it by this bench itself.
Lordship, that's for the
and the lawyers from Delhi argued. And then this matter went, at least the materials have come. And the matter went up there and it's been, in fact, I think maybe increased the cost.
Yes. I'll oblige.
Much obliged, Lordship.
Yes.
I have a small indulgence, my lord, in that public compensation case. I'm sorry, my lord, the other day I couldn't appear, couldn't make my submissions, my lord.
Public revenue?
For that compensation case, my lord,
yes.
Which was fixed on Wednesday.
Yes.
My lord, though I had prayed for fixing it on Wednesday, my lord, I couldn't come because of some personal difficulty, my lord. I was directed to place some judgments today,
yes.
my lord. Besides the judgment, I would like to, my lord, praying for my lord, some bullet points from my end because I couldn't.
No need bullet points. Just give authorities on.
I couldn't respond, my lord. They had raised so many issues, my lord, especially section 14 and 28 of RI Act also, to which I have some kind of a response, my lord. Giving giving a judgment would be burdening your lordship with the lengthy judgment. So I was thinking if my lord could allow me to just file some bullet points, my lord, along with the judgments.
Okay, today.
Today, my lord, I'll try to file it today.